And now, Legal Perspective with Nick Clekis.
Not every legal dispute warrants a full-blown courtroom battle. Sometimes, the quickest path to justice is through small claims court. Let's welcome back the owner of Clekis Law Firm, Nick Clekis. Nick, great to have you back with us.
Thanks.
Again, I want to start with the basics. What is small claims court?
Well, small claims court is, considered a lower court in our system that has jurisdiction up to $7,500. And it's designed really for a litigant to go pro se without an attorney. Okay. You can certainly bring an attorney, but it's designed for you to walk into the small claims court office, fill out a fill-in-the-blank complaint, give it to the clerk with $80. They will then file it and serve it on the defendant, or the sheriff will serve it on the defendant, and then the defendant has 30 days to answer and/or counterclaim.
So you can have an attorney, but it's not required.
Correct.
What other ways does small claims court differ from traditional court?
Well, it's really the same but smaller. So if you decide that you want a jury trial and you notify the court 5 days in advance, they have to provide a jury. They'll do a 6-person jury. If not, it's a bench trial. And when I was a small claims court judge, most of the cases that I heard were bench trials, and it's somebody coming in. And if the defendant doesn't answer, then the plaintiff is provided with a default hearing, and just the plaintiff shows up and states their case, and then the judge just makes a decision as to what amount to give them. Wow. It becomes more of a damages hearing.
Yeah. So if you do not have an attorney, how do you get this process started?
So you go to the small claims court, and I provided the graphic for where it is on Bridgeview Drive. And they have a form that you actually just put your name, the other person's name, and statement of the case, and give them $80. They file it, they'll serve it. 30 days later, either you'll have an answer or you'll be notified of a default hearing date. If they file an answer, then the other party shows up and you try the case in front of the judge if nobody requested a jury trial, and the judge then makes a decision that he finds for the plaintiff or he finds for the defendant, no money's owed, or whatever the case may be.
So at that judgment, so let's say that the plaintiff is they're owed money. What does that process look like? That the payment process? I don't even know where to start.
Yeah, it's a good question. Like in any court, if you prevail at court, whether it's small claims, state court, or federal court, you get a judgment, and then that judgment gets filed with the clerk of court. And that judgment is valid for 10 years, and it gains interest at judgment interest rate, which is actually very high. And then that judgment can be provided to the sheriff, and the sheriff will then research whether or not there are any assets that the defendant has, such as things that you pay taxes on. You've got a car, a house, an RV, a boat, or whatever, and so long as they're not exempt, there are certain exemption rules. They're not going to come and take your house or whatever. The sheriff will actually go and get the asset, like go tow a car off a person's property, or they'll return what's called in Latin nulla bona. In other words, there's nothing there to seize, and you can't collect your judgment.
Okay, you can't collect it.
Well, if they're judgment proof, if I sue you and I get $1 million, $7,500 judgment, and you live in a trailer with no assets and you don't own it, you're just renting, and what's there to get?
Yeah, and the $7,500, that's the jurisdictional limit in South Carolina.
Correct.
And one more question. The attorney's optional in small claims court, and after speaking with you, I feel like you should always have an attorney.
Always.
But in situations like small claims court, what is the reason why someone should have an attorney, or should they just always have an attorney?
No, not really. I mean, again, when I was a judge, I had certain landlords that had cases all the time, and they were pretty proficient at bringing their case, and they knew the system, and those people were a pleasure. It's the people that really don't understand the process that may want to. The problem is that you either, it's not a problem, but of course you have to pay an attorney, or they're going to take a contingency fee amount, and so it diminishes what you actually put in your pocket unless attorney's fees and costs are separate from what you're actually owed.
Well, as always, if you're dealing with a small claims court case or any legal questions, 843-900000000, Clekis.com is where you can go for more information. Nick, thank you so much.
Thanks.
Always a pleasure.
Thanks.
We're back after this.
This has been Legal Perspective with Nick Clekis.